Yes.
My Lord, we were instructed to take consent of instruction from our clients with regards to item number 7 on whether they are willing to refer the matter to mediation. So the
7.
yes, my Lord. Part 2, my Lord.
Part 2. Yes.
So they are willing to refer the matter to mediation, my
7.
Lord.
Okay. Heard Mr. L.H. Lianshima, Learned Senior Counsel for the appellant, assisted by Ms.
Rutlal
Rotfeli, Learned Counsel, along with Miss Rosie Lomsangi, Learned Counsel for the respondent. Full stop. Both the counsels submit that the parties are willing to have the matter referred to mediation. In view of the above, matter to be sent for mediation, registry to do the needful. Yes.
Obliged.
I seek your Lordship's indulgence in mentioning item number 11 of part 2, your Lordship. I've taken the consent of all the parties concerned. If this matter may be fixed on the 18th of September, your Lordship, Thursday.
On the
18th. Thursday, your Lordship.
heard Ms. Lalui, Learned Government Advocate for the state respondent.
Yes, your Lordship. 3 and 4.
Respondent, isn't it? Huh?
Yes, your
Who
Lordship.
has prayed for listing the matter on 18/9/2025. Full stop. She mentions that consent of the other parties have also been taken. In view of the above, list the matter on 18/9/2025. Yes.
Much obliged, Lordship.
May I seek your Lordship's indulgence to mention item number 12 of part 2? In this regard, my Lord, if this matter may kindly be fixed for this coming Thursday, that is
We
the
have already
18th.
fixed one matter,
Fixed?
and I think this is going to take some time. This coming Thursday, there's already one matter listed. So, you want it in the next week? It'll have to be in the next week.
Okay, my Lord. Yes, my Lord.
Thursday, if I'm not mistaken, item number 11 would most probably take some time.
Friday, my Lord.
Okay. Have you taken the consent
Yes,
from
my
the
lord.
other side?
Yes, my Lord.
Mention is made on behalf of, okay, no need to pass any order. This is during this week, isn't it?
Yes, my Lord.
No, but Friday, I don't think it's possible because we have a program at Setsi. So the case will be, so in the next week.
Yes, my Lord.
Mention is made on behalf of Mr. Jordan Lalruhingtama, Learned Counsel for the appellant for adjournment of the matter with the consent from the other side. In view of the above, list in the next week. Yes.
Motion item 1.
May I proceed, my Lord? The matter before your Lordship is a prayer for the issuance of the writ of mandamus under Article 226 and an appropriate direction, an appropriate order directing the respondent to pass the final award, including solution and interest as per the Act of 2013. Brief facts of the case and the...
You had appeared before Lok Adalat, isn't it?
Yes, my Lord. So, my Lord, in 2020, my land was taken by the respondent in connection to the realignment and widening of National Highway 44A. Thereafter, in 6/2/2020, I have made a complaint to the respondent number 2.
So you are the owner of landed property where?
Located at Kortethoving, Mami district.
Okay. So, and then your landed property damage was caused due to the construction of 2-lane.
Two lane,
so
yes.
And so, huh?
Yes, yeah.
And now you're praying for compensation. which
Yes,
has
my
not
lord,
been paid to
the-
you, is it?
Assessment was completed, and the assessed amount has also been provided.
Where?
And you may please find in page number 10, 9, my lord.
Then why weren't you paid?
The reason is the assessed amount has not been paid in full. It was paid in partial, some portion.
How much has been paid to you?
My lord, I have about 5 petitioners. So let me take one petitioner, that is 2,82,450. Out of this is the assessed amount for the first petitioner.
Page 9, this is the assess amount, isn't it?
Yes.
In page 9.
Yes. And in page 10, I have been paid 70,000.
Okay, full amount has not been paid.
Yes.
And why not? No reason given?
No reason given.
But then you had this thing, if you look at page 11, you had approached Lok Adalat, isn't it?
I have approached the local
Registered
and
payment of entire assess amount of compensation.
yes.
Then what happened in the Lok Adalat?
The Lok Adalat was disposed, and you may please see, my lord, page number 55, that is the English translation, the order of the Lok Adalat.
You are happy with the order?
No, my lord.
Then
The
should be an appeal against the,
reason
Page
here,
55.
my lord, yes,
okay, now page 50, okay, it was not settled.
it was not settled.
And then complaints were,
Here in
so
this
here it
Lok-
says that the opposite OP has no
OP
involvement. Who's
OP
the
is
OP?
respondent number 2.
Okay, but the
Yeah,
others didn't
The other
come.
was not included.
Okay, so it's not respondent number. Okay, anyways, so some amount has been paid, full amount has not been paid. So the instant writ petition is filed because of that, isn't it?
Yes,
As
my lord.
simple as that. Will you show notice?
And also the
Uh,
solatium and interest has not been calculated.
not
Not
calculated.
calculated.
So is this an award or what? What is this
This
assessment?
is the assessment. You may please find, my lord, in page number 36. Page number 37 is the English translation. That is Annexure 11. The surveyor assigned have submitted the assessment of compensation to the respondent number 8, that is settlement officer. And in the next page, 38, 39, 40, 41, 42, you
Okay, will you show
That is-
notice? Let's see what's going on. Heard Mr.
Simon Tang Asylum.
Simon Asilo, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or direction to the respondents on the grounds that the petitioners, okay, the petitioners are the owners of landed property at Korte Thoving village, Mamit district, which was taken and damaged by the respondent authorities in connection with the construction of realignment and widening of 2-lane of NH-44 capital A from 11/00-1145-618 kmp under sub-NE between Lengpui to Langkai within Mamit district in the year 2020, so way back, is it? The Learned Counsel submitted that the damage caused due to the construction of the road was duly assessed and some amount of the compensation was paid to the petitioners. However, the respondents failed to pay the whole assessed amount till date, and the assessed amount also does not include solicium and interest. Full stop. In view of the above, the petitioners has filed the instant writ petition for payment of the full amount due to the petitioners. Full stop. Issue notice to the respondents. Ms. Vanesiami, learned government advocate, accepts notice on behalf of state respondents number.
Sole respondent.
In behalf of the state respondents. No need to issue a formal notice. Requisite copies of the writ petition to be duly furnished to the learned government advocate. List after 3 weeks.
Admission item 2.
My Lord, I'm appearing for the
Yes.
petitioner item number 2, my Lord. As per the last order, my Lord,
Okay.
the service has been served upon respondent with 3, 5, 6, 7, and 8, and they have also filed their counter affidavit. And service is yet to return for respondent number 2 and 4, my Lord.
Respondent number 2 and 4. Is
Yes.
it? Who
And
is
as per
2?
the office noting, the ID card has not been returned yet.
So we'll await for AD card from respondent number 2 and 4, isn't it?
Okay.
Return of
All right.
AD card. Who is 2? Who are they? Any
Respondent-
idea? Who are respondents number 2 and 4?
Respondent 2 and 4 will be
One respondent number 2, because if the government is also duly represented, you are representing some of the private respondents.
Yes, my
is
lord,
it?
I'm here for respondent 1, 5, 6,
Okay.
and 8.
So 2 and 4 are not private respondents or what?
they are private respondent, my Lord.
You're not going to represent them?
I am,
They have not contacted you?
yes, they have not contacted us, my lord.
Is the matter similar with the others? Maybe they don't know that they're supposed to contact you. Anyway, we'll await for return of AD card. In the meantime, you can inform the other private respondents here that you're representing, that if it's required,
Yes, my lord.
they could also engage you if the matter is the same. Anyways,
We have
Mr.
received the affidavit filed by respondent number 1, 5, 6, and 8 also, my Lord.
1, 5, 6, and 8, they are represented.
And yes, my lord, we had submitted our affidavit in reply.
Okay, so you want to file your reply?
Yes, we won't file or rejoinder. my Lord.
Okay. Heard Mr.
T. Maranga.
T. Manga, learned counsel for the petitioner, who submits that they may be allowed to file their rejoinder affidavit to the counter affidavit filed by the private respondents number 1, 5, 6, and 8, full stop. It is also seen that AD card from respondents number 2 and 4 is not returned till date. Yes, Lan Nundlu, anything?
Yes, Your Lordship, if 3 weeks time may be granted to
Okay.
file affidavit in
Ms. Lan
opposition.
Nundlu, learned government advocate, appearing for respondent number
10, Your Lordship.
10, has prayed for time to file the counter affidavit. In view of the above, list the matter after 3 weeks.
My Lord, if I kindly accommodate with a fixed date after 3
On,
weeks.
on? 3 weeks, any date after 3 weeks?
7.
7, 10, is it?
All right, my Lord.
2025, full stop. The presence of Ms.
Rosie Manlon.
Rosie
My Lord,
Lalomsani,
there's an interim if
learned
you kindly
counsel for
continue. Then it-
respondents number, the same, 1, 2, whatever, 1, 3?
1, 5, 6, and 8, my
1,
lord.
5, 6, and 8 is noted. Full stop. Then, meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Item 3.
Similar order or what? 3, same?
Item 3, my lord,
Notice complete?
notice
Not yet.
complete. We have not received any counter affidavit yet.
My lord, I am for respondent number 1 and I have already submitted my affidavit in opposition.
Okay,
On
counter
5th of
filed,
June.
huh. So, respondent number 1, they have filed a counter affidavit, though you're saying not received. Have you received a copy? Have you given a copy?
Yes, my lord.
So,
We
you'll
have-
most probably want to file your rejoinder,
Yes.
isn't it?
Yes, I will file a rejoinder.
Oh, yes. Heard Mr. So-and-so, learned counsel for the petitioner, then full stop. Also heard Miss
H. Le Rausange.
H. Lausangi, learned counsel for respondent number 1, who submits that they have filed their counter affidavit. Full stop. Then Ms. Lalun Lui, learned government advocate, has prayed for time to file their counter affidavit. Full stop. Then the learned counsel for the petitioner has also prayed for time to file his rejoinder affidavit to the counter affidavit filed by respondent number
File
1.
number 1.
In view of the above, list the matter on same date,
Same
7,
date, same date.
10, 20.
There's an interim, may we continue, my lord?
Meanwhile, interim is there? Interim
Yes.
order passed earlier shall continue till the next date of listing. Yes.
Item 4.
Your Honor, my lord, in this, we have received the counter affidavit, my lord.
So time for rejoinder? Yes,
Yes, ma'am.
notice complete on all the respondents? Yes, who is representing respondent number 11?
Is this,
That is state, your lordship. State-
Oh, that's a government.
Yes, your lordship.
Ah. Have you filed your
No,
counter?
your lordship, if you may be granted.
What's the matter about? It's concerning whether
my lord, is
you have filed the
concerning.
due provisions of law, isn't it? Something
Yes,
like
my
that?
lord, where the district judge has delegated the power to the district commissioner.
The law is there. It is the district judge, I think.
Yes,
And
my
the
lord.
district judge has delegated the power to the deputy commissioner, collector maybe, okay? So file your rejoinder on that. It's, file your counter to that. It's not difficult, isn't it? Simply praying for time. So it is the state who appears maybe to have taken steps which is beyond its jurisdiction. We can dispose of these revision petitions easily, okay? We just look, and then maybe the petitioners have also some authorities to rely on. These are not difficult matters. It's just the question of whether the district judge is given the jurisdiction or the power to empower the deputy commissioner concerning the additional whatever compensation that is to be paid, to take steps, isn't it? Look into that point. Yes, anyways, heard Mr. So-and-so, learned counsel for the petitioner. Also heard Ms. So-and-so, Lomsani, learned counsel for private respondents number 1 to 10,
my lord.
who submits that they have filed their counter affidavit, full stop. Then Ms. Lanlundui, learned government advocate for state respondents number 11, has prayed for further time to file her counter affidavit. Full stop. Then the learned counsel for the petitioner has also prayed for time to file his rejoinder affidavit to the counter affidavit filed by the private respondents. Full stop. In view of the above, list on same date, interim
May con-
meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Item 5.
My lord, here also we have received one counter affidavit.
By
filed
private
by the-
respondents.
Yes, my lord, one,
Notice
two-
is complete upon all the respondents. Let's see the last court's order.
Yes, my lord, not completed yet to certain.
So, AD card from respondents number 3, 9, 10, 21. Is it? Let's see the,
Yes, ma'am.
wait, let's see. Okay, wakalatnama
No.
is received in respect of 3/21/34/40. So the remaining respondents we have to wait. You are
Yes.
representing? Yes, anyways, I heard Mr. So-and-so, learned counsel for the petitioner, full stop. Also heard Ms. Caroline, no,
Rosie.
also heard Ms. Rosie, so-and-so, learned counsel, who submits that they will be representing respondents number
1 to 12 and
1 to
14
12
and 14 to 51.
and 14 to 51. Okay, they will be representing the private respondents. Okay, 1 to 12 and 14 to 51. And full stop. So between 12, so it's only 13.
Only 13, my lord.
It is, full stop. It is seen that AD card from private respondent number 13 is not returned till date. We may await for return of AD card from respondent number 13. Yes, private, have you filed your counter?
Yes, we have
my lord,
received-
we have
Okay.
filed our counter affidavit.
The learned counsel for the private respondents submit that they have filed their counter affidavits, to which the learned counsel for the petitioner has prayed for time to file his rejoinder affidavit. Full stop. Then Ms. Lalunui, learned government advocate for respondent number 52, has prayed for further time to file their counter affidavit. In view of the above, list the matter of on so-and-so, same date, interim order passed earlier shall continue till the next date of listing. Yes.
Item 6.
In item 6 also, my lord, service has completed. We have received the counter affidavit from the private respondent, my lord.
Okay. Heard Mr. So-and-so, learned counsel for the petitioner. Also heard Ms. Rosie So-and-so, learned counsel for all the private respondents,
5,
for
my
the
lord.
private respondents who submit that they have filed their counter affidavit, to which the learned counsel for the petitioner has prayed for time to file their rejoinder affidavit. Full stop. Ms. Lalnundui, learned government advocate, has prayed for time to file their counter affidavit. In view of the above, list on so-and-so, then same, meanwhile, interim order passed earlier. Okay. Yes, Lalnundui, if you prepare one counter affidavit,
Yes,
it's going to be the same for all the
Yes, Your
cases.
Lordship. Yes, Your
It's
Lordship.
an easy matter.
Yes, Your Lordship.
Yes.
Item 7.
In item 7, my lord, service has been completed. We are yet to receive any counter affidavit, my lord.
You have received or yet to receive?
We have not received any, my lord.
My lord, I have already filed my counter affidavit.
So you say
For respondent number 1, acknowledgement receipt is also
acknowledge is there, please find out.
Alright.
Okay. Heard Mr. So-and-so, learned counsel for the petitioner. Full stop.
We'll file our rejoinder, my lord.
Also heard Ms. So-and-so, learned counsel for the sole respondent, for the private respondent, so, okay, respondent number 1, who submits that they have filed their counter affidavit. Full stop. The learned counsel for the petitioner has prayed for time to file his rejoinder affidavit. Full stop. Then again, Ms. Lalunui, government advocate, has prayed for time. Okay. Then list the matter on so-and-so. Same order, meanwhile.
Interim may continue, my lord.
Item 8.
Your Lordship, in this matter, although the TCR was called for, only the record of the CMA was sent from the trial court. However, Your Lordship, the order sheet and the civil court proceedings record will be required.
It is seen that TCR has arrived.
Yes, we have checked it, my Lord. This is in respect of CMA only.
Okay.
Yes. Civil suit 81 of 2019 will be required.
Heard Mr. Bilaram Enga, learned counsel for the petitioner, along with Ms. C. Tanthiang Hema, learned counsel for private respondent number 5, and Ms. Lal Nuntui, learned government advocate for respondents number 1 to 4. Full stop. It is seen that though this office in its order dated 12/09/2025 had noted that TCR has arrived, however, it is submitted by the learned counsels that the TCR received is with respect to
CMA 588 of 2024.
588 of 2024, while the connected civil suit.
Yes,
is it?
81 of
Civil suit
2019.
number
81 of 2019.
81 of 2019
Sorry,
is
my lord.
required,
Oh, 19, yes, it is correct.
is required in the instant revision petition, full stop. In view of the above, the TCR in respect of civil suit number, okay, of 2019 is to be called for. List after 2 weeks.
After 2 weeks.
Item 9.
My lord, my lord, in this, we are waiting for the,
Okay, they should have continued, isn't it? In between, a different case was put up.
Yes,
Huh?
it-
Anyway, 9, same order.
yes, my lord.
What? Notice complete or not yet?
Completed, my lord, on the previous order, that is 18/7/2025, notice was issued to respondent number 47 and 63, and the edict has returned, my lord. Return service, my lord.
Okay, received or what? Let's see the correspondence file. Postal receipt, this is only postal receipt. So AD card is not returned yet. You have to wait for
All right, my lord.
completion. AD card is there for respondents number 47 and 63. Okay, AD card returned, is it? Anyone
ma'am.
representing the private respondents number 47 and 63? Yes. Are you representing them, Mr.?
No, my lord, I'm not representing the...
So
I'm
you're
representing some of the
representing the
respondents.
private respondents, but
Not all of them, my lord.
latest ones, 47 and 63. You're not representing these two, is it?
Yes, I'm not representing this.
You should be informed, they should be informed that you're representing, because the matter will be the same, isn't it? Anyway, we'll wait for some time for them to be duly represented. And then have you filed a counter?
Yes, my lord, the respondent number 1 has filed the affidavit, which will be relied upon by the other respondents.
Okay.
I represent.
Then you will have to file a rejoinder.
Yes, my lord.
State, we have not yet filed, my lord.
Okay. Look into the matter, state,
If we-
if
if
you
we do not
file
receive-
one counter, it will be the same for all the
If we
cases.
do not receive instructions, we'll be relying on the submission of the private respondents, my lord.
If you do not receive instructions. But see, your reply will be on this thing, a
Only
legal
question
point,
of law.
while the private respondents will be different. I think your counter will be different.
Because, my
Have
lord,
have they addressed the aspect of jurisdiction in your counter?
Yes, my lord, the fact is that the district judge, Kolasip, has rightly exercised his jurisdiction. He has determined the amount of compensation payable to the
Okay, district
landowners.
judge has done
And,
it.
yes, my lord, the direction given to the district collector is only calculation, my lord. The learned First Track Court Kolasip has rightly passed the order.
Okay,
As per
seeing what?
section
The
16(3)
amount.
of the Telegraph Act, my lord.
Okay, we'll have to look at that. Anyways, we'll see. So you're going to rely or you're going to wait for instructions?
I can wait for 2 weeks, my lord. If I
Okay,
do not
fine.
get, I'll rely.
Till
on
the
it.
next date.
Yes, ma'am.
Heard Mr. So-and-so, learned counsel for the petition. Also heard Mr. Lalsan Liana Kiante, appearing on behalf of respondents number. Now, in the previous date, we had listed out. I'll read them out again to see if they are correct or not. Okay, respondents number 1, 3 to 5, 7, 12 to 15, 17, 18, 20, 22 to 24, 27, 28, 31, 33, 35, 42, 45, 46, 49, 50, 52 to 62.
And 64.
52 to 62, isn't it?
Yes. And 64.
Who submits? And?
64.
Okay, 62, then 64. Okay. The Learned Counsel for the private respondents submits that they have filed their counter affidavit, to which the Learned Counsel for the petitioner has prayed for time to file his
File now.
rejoinder affidavit, full stop. And then Mr. Samuel L. Sanke, Learned Additional AG for the state respondents number 65, has prayed for time to file their counter affidavit. In view of the above, this is the matter, same date, then interim order to continue. Yes.
In the next item, my lord,
Item 10.
20.
Notice complete? Oh, wait, in the last
Yes, order.
case, item number 9, you can add also, it is seen that AD card from respondents number 47 and 43 are returned. In view of the above, notice upon all the respondents are, private respondents are complete, we may await for the private respondents who are not duly represented to be duly represented in the next court date. Okay. Then after that, meanwhile, interim list on so and so, interim order. Yes.
My lord, in the next item, CRP number 20, on the last date, the respondent 2, 3, 4, and 5 was not represented yet.
Are they being represented today?
No. I'm for respondent number 1, my lord. I have
Okay,
filed
only
the
number 1.
affidavit. And the other respondents are not represented.
We'll wait for them to be represented, yes.
My lord.
But maybe your counter affidavit could be relied on upon also once the matter is heard, isn't it? He has heard Mr. So-and-so, Learned Counsel for the petitioner, also heard Mr. Lalsan Kyangte, Learned Counsel for respondent number 1, and Mr. Samuel L. Changte, Learned Additional AG for the state respondents. Number 6, maybe?
Number 6, ma'am.
6, wisdom. It is seen that counter affidavit has been filed on behalf of respondent number 1, while none appeared to represent the private respondents number 2, 3, 4, and 5. Wisdom. We may await for the other private respondents to be duly represented. Full stop. Meanwhile,
I may be allowed to file my rejoinder, my lord.
the Learned Counsel for the petitioner may file his rejoinder affidavit to the counter affidavit filed by respondent number 1. The Learned Additional AG is also to file his counter affidavit. Then list on same date, meanwhile interim order passed. Okay, same order.
Item 11.
My lord, in CRP, item 11, CRP 21 of 2025, on the last date also, my lord, we are still awaiting for the returning of AD cards, my lord. On respondent number 29, 31, 32, and 33.
Return of ED card. Do you want to issue fresh notice or we keep awaiting? We can keep awaiting, meanwhile the case can go on, isn't
My
it?
lord.
If you have filed, if counter affidavits have been filed, rejoinder, because I think the counter affidavit for the other private respondents would
Yes, my lord. Will be in this payment.
also answer the, for the other missing respondents, isn't it? But we'll have to see, but they should be knowing that there's a case filed against them. Anyway, we'll wait for some time. If not, maybe you'll have to take steps through newspaper publication also. I heard Mr. So-and-so, learned counsel for the petitioner, full stop. Also heard Mr. Lalsandiana Kyante. Learned counsel for respondents, same, or do you have any new respondents?
No, my lord. The same
For respondents number 3, 7, 14, 19, 21, 22, 24, 27, 30 and 34. And Mr. Samuel Wallace Gathanke, learned additional Advocate General, appearing for respondent number
37.
37.
And the respondent 24 has filed the affidavit, and which will be relied upon by the other respondents.
The learned counsel for the private respondents, as mentioned above, submits that the respondent number 24 has filed the counter affidavit, and the remaining respondents would like to adopt the said affidavit filed by respondent number 24. Full stop. The learned counsel for the petitioner has prayed for time to file the rejoinder affidavit to the counter affidavit filed by respondent number 24. Full stop. The learned additional AG has also prayed for time to file his counter affidavit. In view of the above, list on same date, meanwhile interim order.
My lord.
Item 12.
My lord, is the CRP 22 of
Oh, what is the stage here?
this service is complete, and the respondent number 1 has filed the
Okay, counter filed, so you have to pay
Yes.
rejoinder, isn't it?
Yes,
Yes,
ma'am.
heard Mr. So-and-so, learned counsel for the petitioner. Also heard Mr. Lalsandiana Kente, learned counsel for private respondents number 1 and 2, and Mr. Samuel L. Sanke, learned additional Advocate General for state respondent number 3. It is seen that affidavit it is seen that counter affidavit has been filed by respondent number 1, and the remaining private respondent will adopt the said counter affidavit filed by respondent number 1. The full stop. The learned counsel for the petitioner has prayed for time to file his rejoinder affidavit. Full stop. That's the matter on same date. Meanwhile, counter affidavit may also be filed by the state respondents number 3. Is it?
3.
yes, my lord.
3. Full stop. Then, meanwhile, interim order.
Highly obliged, my lord.
Item 13.
Yes. Yes, petitioner.
May please, Your Lordship, I am here for the petitioner, but I have been informed that the respondents will seek for adjournment
If you
in
see
this
a letter,
matter.
let us see. You just be there. Your petitioner is present while respondents.
May I please, Your Lordship? Lordship, I am appearing on behalf of SK Committee for respondents.
Yes.
Lordship, kindly fix the matter after vacation.
Okay. What is the this thing?
We have no objection, my lord.
Okay, no objection, no urgency. Okay. Heard Miss, your good name?
R.
Sakia.
Yes,
Learned
R.
counsel appearing on behalf of Mr. S.K. Medi, learned counsel for the respondents. for adjournment of the who has prayed for adjournment of the matter by submitting that the counsel for the petitioners is not able to appear due to some personal difficulty. First of Ms. So-and-so, learned counsel for the petitioner, has not raised any objection. In view of the above, this is the matter after the ensuing vacations. Yes. You want a date? No. After the
Can it
vacation.
be on 28th of October, Lordship?
On 28th.
Yes, 28th of October.
10, 20, 25.
Item 14.
My Lord, in item 14, I have received affidavit filed by the two respondents, 1 and 2.
How many respondents are there?
There are 2 of them, my Lord. They have
So
both
from the
filed. So,
respondents,
yes,
I'm for the respondent number 1.
pleadings is complete, my Lord. It can be
who's for 2? Okay, again, maybe.
Mr. Mehdi.
I am appearing for respondent number 2 on behalf of SK.
No objection, isn't it? Ms. So-and-so appearing on behalf of, again, SK Mehdi, learned counsel for respondent number 2, has prayed for adjournment of the matter since is the learned counsel. Okay, same. Then Ms. Rosie Somlomi, learned counsel for respondent number. No, Ms. Okay, Mr. Silal Fakoma. Okay, learned counsel for respondent number 1, and Ms. Linda L. Fomberg,
PP.
learned PP for the state respondents have not raised any objection. Okay, in view of the above, is the matter same day. Okay. Yes.
Obliged.
Item 15.
Yes, you are for the
Petitioner, my lord.
petitioner.
Yes, my lord.
Who is for the opposite party respondents?
I don't know, my lord.
TJ,
Yes, Mr. TJ.
Anyway, we'll fix some other date. Let them be represented. What is the criminal complaint about?
My lord, I'm seeking for, by filing this criminal petition, I'm seeking for questioning of the order passed by the lower court in criminal complaint number 597 of 2025.
This is concerning cheating, is it?
Yes,
What's
my lord.
this? 82.
Yes, my lord.
82, 1 of BNS is the same as 420 IPC, is it? What is 82 for cheating? Anyway, none appeared for the rest. Oh, yes, here, yes.
Sorry for my...
Yes, so
Yes, my lord, I'm not submitted my affidavit in position. In the last court date, the honorable court allowed us to
objection,
submit oral submission.
so you don't want to file a written,
No, my lord,
Okay.
for oral submission only.
okay, then we'll hear the matter. Yes, Miss, you can continue.
Yes, my lord. The present petitioner is Israeli nationality, and she is wrongly accused. She is wrongly added as co-accused in this criminal complaint.
Let's see the copy of the criminal complaint.
It's in
Page.
annexure number. Annex D. Page
Annexure?
number 14.
14,
Annex
1,
D.
4. Yes, what does it say?
That the complainant
This is
is
between husband and wife, is it?
Yes, my lord.
So what is the complaint? Complaint is made by the wife, is it? Against the husband. On what grounds?
My lord, the complainant in this criminal complaint and the respondent are husband and wife. And the husband, David Lal Nunsiama, went back to Israel after being married to the complainant. And then he
When did
promised...
they get married? Marriage certificate? Yes, here's a marriage certificate. They got
It's in
married
page
on
20.
1st March. They got
Yes,
married on 1st
1st
March
March
2023.
2023.
Okay.
And then after on, he got engaged with another woman in Israel. And then he got his second marriage. He married again in 17/9/2024 in Israel. And then the present petitioner came to Mizoram as a tourist to visit their relatives. And
No, they got married on 1st, 3rd, 2023, isn't it?
yes, my lord.
Then after that, what happened? He left her, or they were
No, he
staying
went-
together as a couple?
They stayed together as a couple,
Okay,
and
couple.
then he went back to Israel.
Okay, when did he go back to Israel?
I think after a week after they got married.
Okay, after 1 week of their marriage. Okay. 1 week, then he left for Israel. Is it? Then he came back to Aizon.
No,
No,
my lord.
okay. After 1 week of marriage, he left. Then what happened? Then you got to know that he got married again.
Yes,
Where? In Israel?
yes, my lord.
How did you get to know about that?
From their relatives.
From the relative. Special Marriage Act. Okay, they got married as per the Special Marriage Act. So what is this photograph, page 29? 28?
28.
This is a photograph of
Yes,
his marriage to you or his second wife?
his second wife.
Okay, because of these photographs, is it? Okay,
My lord, if you can read page number 26, my lord.
36,
26, my lord.
26.
It's message to his wife.
Is it there in the, yes, 27, you have to read 27, the Visa vernacular.
The translated copy. Ethel, I am so sorry I did not even have the courage to call you. Let me just say it straight, I can't bring you here. As you have said earlier, I have been thinking about a lot, and maybe it's best if we get a divorce. There's just no way I can bring you here. Please forgive me, but I know this, I will take responsibility for the thing we have done together, like loan. I'll help you repay until the very end. It's not because I don't love you. I do. But right now, I am mentally exhausted and broken inside. I don't even have a courage to call your father, to talk to your father and anyone else. I feel so ashamed. My life feels like it's falling apart. Please forgive me for everything and all of it. It was my fault. Ethel, you once told me before that there are a lot of good men out there. I am not good enough for you.
So what loan did you take during the marriage? I think that's the main reason you have come to the court.
The business loan, my lord.
So when did you take the loan? Because you were together for only 1 week, isn't it? After the marriage.
Yes, my lord.
Where's the loan, documents for loan in your name, is it?
Yes, my lord. Page number 25.
25. It's in
23
your
to
name,
25.
is it? 23 to 25.
Yes, my lord.
So loan was taken in your name. How much did you take? 8 lakhs, is it?
No, my lord, the loan was taken in the name of Ethel Rodriguez, the other
Okay,
party, the
Ethel.
respondent party. Yes,
That is the name of the,
respondent.
okay. Wait, now I'm lost. Lal Nunziri is the first wife. You're the first wife.
No, ma'am. I'm sorry.
Ah.
No,
Who
my
is
lord.
Lal Nunziri?
Lal Nunziri is the mother of the
Okay.
David the petitioner.
You are the mother.
Yes.
And your
She was-
daughter. Who is your daughter?
No, my son. My son and the respondent were married. They were married, and then
Okay,
my
I was
son went
under
back to
impression that you
Israel.
were the wife and that you got married. No, it's not
No,
that. So
that.
come, let's get back to the
Yes.
facts of the case.
Yes, and then
You are you are the mother
mother of the petitioner.
of the
Petitioner. Of the in the criminal complaint, my son is the respondent.
So you are filing a case against your son.
No, my lord.
I'm not understanding you now. I'm completely lost. Yes.
The respondent and my son were married, and then I was wrongly added as co-accused in the criminal complaint.
Let's see the criminal complaint again. So the criminal complaint is still pending, is it? Before the judicial magistrate. Okay.
Yes.
You are the mother of your son, obviously. And your son got married to the respondent. Okay.
Yes, my lord. Yes, the present criminal petition arose from criminal complaint of 597 of 2025, where the present petitioner is a citizen of Israel. She was arraigned as a witness to the criminal complaint. She was summoned, but however, since the petitioner is a citizen of Israel, she could not be present before the court. And due to her absence, the learned counsel for the complainant requested to issue a non-bailable warrant of arrest against the petitioner. From there on, the petitioner was added as co-accused with respect of the complaint on the ground of cheating.
So,
her son is the main accused of the instant criminal complaint, and she was arrested in connection with the allegation of offense committed by his son.
by her son.
Yes. Oh, I'm sorry.
What is the offense
By her
committed
son.
by her son?
Cheating.
Cheating.
Yes.
Cheating because of the loan. You admit all that?
No, no, no.
Then cheating of marrying someone else?
Yes.
Okay. So what does the loan has to do here? You have filed some documents showing that loan was taken from Rural Bank. This has nothing to do with you.
No, my lord.
Okay, show me some documents to support your claim. Let's see the criminal complaint.
My son
Okay.
promised his ex-wife.
Where's the warrant of arrest copy?
It's in the see.
Or we can read the whole criminal complaint as to how you are involved. Is your name here in the criminal complaint? So here, a complaint was filed by Ethel Lalwar-Diki. Now, who is Ethel? Ethel is the respondent versus David Lalnun Siaman, who is your son, isn't it?
Yes, my lord.
So there's a case going on between them. Whatever the case is, you're not concerned with that. But your involvement comes when a warrant was issued against
Yes.
you. Where's that warrant?
Annexures. See, it's in the order passed on date 29/5/2025.
Page
30.
30.
Yes. Annexure
Okay,
C.
so your instant petition is against this order, is it? Read what happened.
Learned counsel for the complainant is present in court. Today is fixed for appearance for OP's mother, Srimati Lal Nunziri, mother of the OP, Sri David Lal Nunsiam, as summoned. However, she is absent
Why were you
again.
summoned? Where's the first order summoning you?
First order, date 10.
You were summoned as a witness or what?
Yes, my lord. I was summoned as a witness since the court believed that
Okay, so if you were summoned as a witness, then you should have gone. You were not made a party. Anyway, continue reading this order then, 29/05/2025.
However,
Point
she is
two.
absent again, and learned counsel stated that she refuses to appear before the court. Learned counsel made a prayer to compel Srimati Lal Nunziri to appear before this court by issuing warrant of arrest. Counsel stated that Srimati Lal Nunziri herself and two other persons went to the home of the complainant sometime in January of 2023 as Palai to discuss marriage proposals before the complainant and the OP, Sri David Lal Nunsiamo, were legally married as per Mizo marriage customs. However, the OP's mother now refutes ever doing such a thing alleged and refuses to acknowledge any marriage between the parties at all. And such OP's mother, Srimati Lal Nunziri, is a crucial
So you were
witness to the
supposed to be a
instant case.
witness, isn't it?
Yes, my lord.
Then, please read.
Learned counsel further stated that the OP's mother is also a citizen of Israel and she is physically in Aizol only on a temporary basis, and her arrest is warranted on the ground that she may soon return to Israel and justice may not be served to the victim. That is the complainant. Heard and perused. On consideration of submissions made by the learned counsel and due to the facts and circumstances of the instant criminal complaint, this court is satisfied that the appearance of mother of the OP, Srimati Lal Nunziri, is paramount. However, even after serving of summons, she was willfully refused to appear in court. She has willfully refused to appear in court. This court also finds prima facie case of cheating against Srimati Lal Nunziri in collusion with her son, who is the OP in this case. This, as per Section 358 of BNSS, issue warrant of arrest non-bailable against Srimati Lal Nunziri to procure her appearance before this court. The concerned police station be given notice to do the necessary.
So let's see, warrant was issued under 358 of the BNSS. Let's see what is the power under 358 BNSS. So the reason, why aren't you appearing before the court as a witness? You don't have to be scared to be a witness. Whatever you know, you just go and depose 358. What does 358 say?
Power to proceed against other persons appearing to be guilty of offense. Clause number 1. Where in the course of any inquiry into or trial thereof an offense, it appears from evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused, the court may proceed against such person for offense which he appears to have committed. Clause 2, where such person is not attending the court, he may be arrested or summoned as circumstances of the case may require for the purpose
So
of
why
force.
aren't you attending the court? Where are you residing? In which locality?
ITI.
ITI. You are not made the accused. The case is between, the complaint is against her son. So all they want is you to appear as a witness. Isn't it? So what's wrong with this order? Anyways, yes, please continue. Here, she has not been made a party, isn't it?
Since the petitioner was Israel nationality, she could not be present before the court, as stated by the learned counsel for the petitioner. The learned court, due to the absence and on the ground of the learned counsel for the complainant.
She's in Israel.
No,
She's here, so she's the one who's been summoned.
Since she is Israel nationality, she could not.
So, why can't she appear? What do you have? What material do you have on that? On what authority are you saying that she cannot appear?
She came to Mizoram with a tourist visa.
So some judgment, some order, some notification. What do you have? On what basis?
She was wrongly arrested, my lord.
She's not arrested. She was just asked to appear before the court. Let her go in the court. Let her say whatever she has to say.
And then after
where's the law that says that you cannot arrest a foreign national? Is there some law? Then?
The thing is, she was arraigned as co-accused.
Where?
In order dated.
No, show me all that. You're not showing me the whole thing. Page of what? Is it here in your petition?
Yes, my lord. Page number 34, order date 9/6/2025.
What the sheet for the magistrate? Read that. This is dated 0906.
Counsel for the complainant is present. Srimati Lunzuri is produced in court in execution of NBWA issued. The accused Srimati Lunzuri has been added as co-accused with
so you
respect to
appeared later. So you're taken to 29/05/2025. Okay.
Yes.
But later you did appear before the court.
Yes,
So
my
say
lord.
that.
The
So
accused
take me to
Srimati
order, yes.
Lunzuri has been added as co-accused with respect to this complaint on ground of cheating. The main accused is her biological son, who refuses to appear in court as he in Israel. Srimati Lunzuri is examined, and she stated that she had refused to receive summons served by the counsel for the complainant, as she allegedly had no knowledge of the instant criminal complaint. She is reminded that had she received the summons, she would have realized that the summons was issued by this court to show cause. She was accompanied by her husband, who was creating nuisance in court and exhibited unruly behavior along with the co-accused Srimati Lunzuri. After an attempt to listen to their side of the story due to the accused and her husband's erratic outbursts in court, Srimati Lunzuri is sent to judicial custody, and the husband as well, as Srimati Lunzuri are informed of their right to engage a lawyer to represent them.
So where are they right now?
She's out of judicial custody.
Out in judicial custody. So?
My lord.
So now she's in judicial custody or she's out on bail?
No, she's on bail.
She's on bail. So?
My lord, the main issue is that she was wrongfully added as co-accused without any genuine case.
How do you say that?
My lord?
How do you say that? Give some grounds for your submission, because so and so and so and so.
By adding the petitioner as co-accused, initially when the criminal complaint was filed before the trial court, perusal of the criminal complaint shows that the accused has been wrongly added as co-accused without any observation in any criminal proceedings. My lord, cognizance has to be taken at initial stage, and all those aspects are silent in passing this order. So the order also stated that on the grounds of cheating. So why was she added as co-accused on the grounds of cheating when all those observations and statements are absent? So
Which all those observations are?
appropriate steps in the event of the criminal proceeding to be initiated against the son. Procedures have to be followed by the lower court, which was not followed, my lord.
Is that it? Okay. Any authorities to rely on? Any judgments of the apex court?
No, my lord.
Yes, let's hear the respondent.
Yes. Yes, my lord. With your lordship permission, I would like to submit the brief fact of the case to ventilate about the case of for the court. The brief fact of the case, some point may be repeated as the petitioner already submitted. The brief fact of the case of the petition that the case is petitioner's son, who is Israel citizen, and the respondent enter into court marriage on 1st March 2023, and only after a week, the petitioner's son returned to Israel, promising to come back soon and to take the respondent with him to live together in Israel. However, upon reaching Israel, it transpired that due to certain official documents and requirements, it would take some time to arrange the necessary papers to bring her to Israel. And in the meantime, with considering the respondent family circumstances, the petitioner in the lower court, the petitioner respondent, the respondent in the present case belongs to a family with a limited financial resources, with struggling to make ends to meet and with meager income, with barely management to for their livelihood. And as the accused David, out of compassion for his wife, he advised her to secure a loan with the understanding that he would repay it. Unfortunately, the petitioner's son did not honor his commitment, leaving the respondent family with a substantial financial burden. Thereafter, the respondent was unable to contact her husband, and the petitioner's son, as he deliberately avoided her calls, and subsequently she discovered that he had married another woman. The respondent was
married to someone else.
Yes, in Israel.
You married someone else.
Yes, in Israel, another woman. She discovered it after deliberately avoided her calls, phone calls, and The respondent was greatly surprised, also utterly shocked and deeply distressed, and her previously peaceful life was thrown into chaos. Even though, my lord, the respondent had attempted to resolve the matter amicably by sending a mediator or conciliators, but their effort was in vain. Consequently, they were left with no choice but to approach this guardian of the people, the Honorable Court. Subsequently, the respondent had filed a criminal complaint alleging commission of offense under Section 82 of BNS 2023 by the petitioner's son. Thereafter, Vite Order 11-2025, the learned trial court examined the respondent as complainant on oath and finding sufficient prima facie material of offense under 319 BNS 2023 against the petitioner's son and issued summons to him. After summons on 11/2/2025, the case was fixed on 16/4/2025 for appearance of the accused, son of the petitioner. However, the accused was not present in the court. Thereafter, 22nd May 2025, the respondent petitioner side submitted before the learned trial court that the mother of the accused, the present petitioner, herein was present in Aizawl and requests that she be summoned to the court for assisting the adjudicating the matter. Accordingly, due to the facts and circumstances of the case and for the ends of justice, the present petitioner was summoned by the learned trial court. On the next court date, 28 May 2025, it was submitted that in court that the petitioner had refused to receive the summons issued to her by the court to appear and to show cause to refute the allegation leveled against her son by the respondent hearing. The case was again fixed on 29 May 2025. On that day, the learned trial court held that the petitioner had willfully refused to appear before the court. The learned trial court also held that there was a prima facie case of cheating against the petitioner and accordingly issued non-bailable warrant of arrest against the petitioner by invoking 358 BNSS 2023, that is power to proceed against other persons appearing to be guilty of offense. And on the next date, my lord, on 3rd June 2025, non-bailable warrant of arrest was returned unexecuted. The case was then fixed on 9/6/2025 for production of the petitioner.
Where do you have all this?
Pardon, my lord?
You don't have any documents?
Yes, I have. It's already in their submission.
Okay.
In their petition only.
Okay.
Yeah.
Okay.
Everything is with there. On 9 June, the petitioner was produced arrest before the learned trial court. The petitioner accused mother was informed and explained that she had been summoned to show cause about the offenses alleged against her son. However, because of her erratic behavior in the court, the Honorable Court found prima facie case against the petitioner and she was sent to judicial custody. The petitioner preferred for bail before the learned trial court, but Vite Order dated 23rd July 2025, her bail prayer was rejected by the learned trial court. Thereafter, the petitioner preferred appeal bail before the learned additional district session judge 2, and the learned judge released her on bail on 18 August 2025. Here, my lord, my submission is that the complaint that was filed by the respondent was against the petitioner Shang and not the present petitioner. Though the complaint was originally filed under Section 82 BNS, the learned trial court find prima facie materials of offense under Section 318 and 319 BNS, that is cheating, and took cognizance thereof and issued summon to the petitioner Shang.
Oh, Santo, it's okay. But
Yes.
how is she involved, the mother?
Yes, my lord, I'll come to the point. Come to the point. I also would like to submit that the petitioner had been added as an accused to the case in terms of 358 BNS.
358 BNS.
358 BNSS.
What does it say?
That is power to proceed against person appearing to be guilty of offense.
Okay. You see, these new sections, unless you
Yeah,
read
that
them,
is in 319 in the previous law,
358.
CRPC.
Please read 358 if it's under 358. What does 358 say?
Power to proceed against other person appearing to be guilty of offense, where in course of any inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused. The court may proceed against such person for the offense which he appears to have committed.
Okay. So the mother was called, she didn't appear. Finally, she appeared. And then
And found prima facie against
the
her.
court found her. So,
So, my lord, I also would like to submit that on 29/5/2025, learned trial court, after considering the facts that the petitioner was evading its summon, had issued non-bailable warrant against that section. Here, the petitioner can be arraigned as an accused by invoking this 358 BNSS. The learned trial court, since the learned trial court found prima facie materials against the petitioner, added her as an accused. There is nothing perverse in adding the petitioner as an accused. Here, my lord, I would like to submit my support that Reliance Apex Court decision.
okay.
Yes. Number of
What is the citation? So that the petitioners also can have a look at the citation. What is the citation? Just mention. It is reported in.
Yes, my lord. It is Kishun Singh and others versus State of Bihar.
Reported in.
1990, reported in 1993, 1 SCR. Supreme Court report.
Yes.
Here, in the case, in the first page, the case is that on the evening of 27 February 1990, informant's younger brother was attacked by 20 persons, including the present two appellants, with stick, etc. First information report was lodged at about 9:30 p.m. on the same day, in which all the 20 persons were named as the assailant. The injured died in the hospital on the next day. In course of investigation, statement of the informant and others were recorded and charge sheet was forwarded to the court of the magistrate, wherein 18 persons were shown as offenders. The names of the present two appellants were not included in the report, as in the opinion of the investigating officers, their involvement in the commission of the crime was not established. The 18 persons named in the report were committed to the court officer section under section 209 of the CRPC stand trial. When the matter came up before the session judge, an application was presented under 319 of the court, praying to implead the appellants also as accused person. To the show cause notice issued to the appellants, they submitted that though they were not present at the place of occurrence, they were falsely named in the first information report, and the investigating officer had rightly omitted their names from the charge sheet filed in the court. The session just rejected the plea of the appellants and impleaded them as co-accused along with the 18 others. This was done before the commencement of the actual trial. And the appellant's revision filed before the High Court was dismissed. Here, the prolonged discussion was there in the judgment.
So, with the operative, where is it?
Operative person in the page, my lord, kindly goes to page 39. Here in the observation point, the new court, in the new court, page 39. Section 319, where in the course of any inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person should be tried together with the accused, the court may proceed against such person for the offense which he appears to have committed. Where such person is not number 2, where such person is not attending the court, he may be arrested or summoned as the circumstance of the case may require for the purpose aforesaid. Number 3, any person attending the court, although not under arrest or upon a summons, may be detained by such court for the purpose of the inquiry into or trial of the offense which he appears to have committed. Number 4, where the court proceeds against any person under subsection, the proceeding in respect of such person shall be commenced afresh and witness reheard. Subject to the provisions, the case may be proceed as if such person had been an accused person when the court took cognizance of the offense upon which the inquiry or trial was commenced. Here, my lord, in another operative portion is in page 47. From page 47, it may be long. I may read. Yeah. We have now reached the crucial point in our journey. After cognizance is taken under section 190 clause 1 of the court, in warrant case, the court is required to frame a charge containing particulars as to the time and place of the alleged offense and the person, if any, against whom or thing in respect of which it was committed. But before framing the charge, section 227 of the code provides that if upon consideration of the record of the case and the document submitted therewith, the session judge considers that there is not sufficient ground for proceeding against the accused, he shall for reasons to be recorded discharge the accused. It is only when the judge is of opinion that there is a ground for presuming that the accused has committed an offense that he will proceed to frame a charge and record the plea of the accused. It becomes immediately clear that for the limit purpose for deciding whether or not to frame charge against the accused, the judge would be required to examine the record of the case and the documents submitted therewith, which would comprise the police report. The statement of the
So you just come to the last para.
Yes, my lord. Yeah.
Where the appeal was dismissed on the grounds that the court
Yeah,
found that
in the
it should not
page number
interfere
50,
at
my
this
lord,
stage.
the next page.
Last para.
Yeah. For the reasons stated above, well as are in agreement with the submission of the learned counsel for the appellants that the stage for the exercise of power under section 319 in the present act is 358 BNSS. The court had not reached inasmuch as the trial had not commenced and evidence was not led, since the court of session had the power under the section 193 of the court to summon the appellants as their involvement in the commission of the crime prima facie appear from the record of the case. We see no reason to interfere with the impugned order, as it is well settled that once or it is found that the power exists, the exercise of power under a wrong provision will not render the order illegal or invalid. We therefore dismiss the appeal. And that is number one. And another citation in Jaswan versus State of Rajasthan in 2009, Supreme Court reports. Here also, my lord, if the lordship permit, I'll go to the operative portion only. Otherwise, it will be take long.
Yes.
In page 718, the last page. The operative portion is para 21, 22, and 23. We may furthermore notice that the question as to whether Kishan Singh has been correctly decided or not, having regard to the decision in Dharampal and others, state of Haryana and others, 2004, 13 SEC 9 is pending consideration before the constitution bench of this case. Despite the same, we have proceeded to dispose of the matter, assuming that the decision rendered by this court in Kishan Singh as correct. So long as the investigation is not completed or evidence are not brought on record, the learned session judge could not have exercised this jurisdiction either under Section 193 of the Code of Criminal Procedure or Section 319 of the Code of Criminal Procedure. The impugned order framing charge against the appellants for the reasons mentioned herein before. Therefore, it is liable to be set aside. We direct accordingly. We, however, keeping in view the fact that the appellants have already appeared and are no longer absconding, direct the investigating officer to submit final form on the basis of the materials collected during investigation. We may, having regards to particular facts and circumstances of the case, would also observe that the learned session judge, if it may so desire, may exercise jurisdiction under 319 of the Code of Criminal Procedure so far as the appellants are concerned, in which event the procedure laid down therein must be resorted to. That also declared that Kishan Singh case is correct in this case. And another citation also will be there, my lord. AIR Supreme Court 2014. It already I already submitted in the last week maybe in the case record.
Where?
In
It's
the
not here.
Oh, okay.
So anyways, she's approaching this court under 528, isn't it, inherent powers? That is previously 482.
This is the case of Hardeep Singh versus State of Punjab. The operative portion in page number 36, in the last part. Here, the question and answer are here, para 109. From para 109. Thus, it is evident that power under Section 319 CRPC can be exercised against the person not subject to investigation or a person placed in the column 2, the charge sheet, and against whom cognizance had not been taken, or person who has been discharged. However, concerning a person who has been discharged, no proceedings can be commenced against him directly under 319 CRPC without taking recourse to provisions of Section 305 read with Section 398 CRPC Parat 110. We accordingly sum up our conclusion as follows. Question number 1 and 3. Question number 1. What is the stage at which power under Section 319 CRPC can be exercised? Question number 3. Whether the word evidence used in Section 319 Clause 1 CRPC has been used in comprehensive sense and includes the evidence collected during investigation, or the word evidence is limited to the evidence recorded during trial. Answer. In the Rampal AIR 2013 Supreme Court 3018 case, the Constitution Bench has already held that after committal, cognizance of an offense can be taken against a person not named as an accused, but against whom materials are available from the papers filed by the police after completion of investigation. Such cognizance can be taken under 193 CRPC, and the session judge need not wait till evidence under Section 319 becomes available for summoning an additional accused. Section 319 CRPC significantly uses two expressions that have to be taken note of, that is inquiry. Number 2, trial. As a trial commences after framing of charge, an inquiry can only be understood to be a pre-trial inquiry. Inquiries under Section 200, 201, 202 CRPC and under Section 398 CRPC are species of the inquiry contemplated by 319 CRPC. Materials coming before the court in course of such inquiries can be used for corroboration of the evidence recorded in the court after the trial commences. For the exercise of power under 319 CRPC, and also at an accused whose name has been shown in column 2 of the charge sheet. In view of the above position, the word evidence 319 has to be broadly understood and not literally as evidence brought during a trial. And in question number 2,
I think
my
we
lord.
leave it at that. I've got your point.
Yeah.
Okay, the main question here is that an application has been made under Section 528 of the BNSS
Yes, madam.
for the interference of this court. Isn't it? Yes. Which you're saying that this court cannot interfere because it is at its inquiry stage.
Yes, my lord.
Isn't it? And a person who was not initially named in the complaint filed by the complainant can also be later included as a co-accused if the court during its investigation, so 3193 etc. comes in. Isn't
The
it?
London trial court also found the prima facie case against the patient.
Okay. But the main thing, it's not concerning the marriage. The case is regarding the loan money.
Loan
Isn't
money
it?
and marriage also.
The complaint, if you look at the nature of the complaint, it's not because of the marriage, but it is because of the loan money. So now the loan money, as per the complaint filed, was used, whether it was all used by the son or was the mother involved also in the money. I think that's the main thing.
Yes, my lord.
Yes. Anything in rebuttal?
Yes, my lord. Regarding that, police inquiry is not being conducted, and charge sheet has not also been made till now. And I would also like to, if the court call for a report to the lower court and
Call for the lower court, the same records, is it?
Yes, my lord.
Let's call for it then.
No, my lord, it is already the case record is here.
Is it here?
No, it must be here. Otherwise, it may not be fixed.
What's the stage?
And
But
My lord.
you should stick to the points, okay? Yes.
yes, my lord.
Not yet? It's not here.
Um,
PCR was not called for. But whatever it is, it's clear that it is during the investigation. Investigation means the court on a complaint submitted. Okay. Had gone ahead, taken evidence, isn't it? Taken evidence. It wanted to record the evidence. He had called you also. You had refused to appear. And then your statement was recorded. It appears. But the copy of your statement is not here. It is after recording her statement that the court found that she could also be involved. It appears from the last order which was read out, the last order of this court. Somewhere the court mentioned that your statement was after hearing you, according to the learned trial court, you could also be involved and you were made a co-accused. You were unhappy with that main order, isn't it?
yes, my lord.
To be made a co-accused.
Yes, my lord.
So here, if you look at the impugned, the last order, I was searching for that. Srimati Lal Nunziri is examined. And she stated that, so when she was examined, was her examination recorded? What was her statement? So when she was examined, was the examination recorded? That's the main thing. Maybe after she was examined, this court found that she could also be a co-accused.
My lord, the fact of the case is that
Regarding the
regarding
loan money.
evidence, for taking evidence that she was opposing that the trial court judge at the time of summon her, she could not answer properly at the time.
The accused Lal Nunziri has been added as co-accused with respect to this complaint on the ground of cheating. So let's look at the complaint again. How was she added as a complaint? This thing. Where is the complaint page?
Complaint.
I don't know whether we really require the case record. Let's look at the nature of the complaint again. I think it's basically, if it's cheating, not so much a marriage. If it's just a marriage, she cannot be involved. But here you have somewhere mentioned loan of so much money was taken. So what is the complaint about? Let's look at the complaint again.
Regarding loan.
A criminal complaint was filed. So what then here I see a lot of bank transactions, so much money was this thing. Marriage, I don't think he can be made a co-accused. Page 14. Avail a loan of 8 lakhs to be paid back. Then you would send monthly loan repayment, isn't it?
Yes, Monday.
Yeah. Then page
Monday with 10%.
8, page para 8.
15. Page 15.
Then the mother, they were dependent on the complainant. Okay, this is the complainant's mother. Complainant is you. Yes, you. I'm getting
No,
confused.
respondent.
We are the complainant in the lower court.
And I
Okay,
am
so
the
your
respondent.
mother, complainant.
I am the sole victim in that Ethel London City, the petition in the lower court.
My lord, let a case maybe proceed against my son, but not against me. Simply added me as a co-accused on grounds of cheating is not warranted.
Cheating, yes, on the grounds of cheating, but because some loan money was also taken, isn't it, by you?
No, my lord, my loan is taken in the name of the respondent.
Respondent is the son. No.
No, my son is the. Yes,
But you had taken loan in the name of your wife, first wife, isn't it?
Ma'am, we do not. I don't know about that.
That's what she's claiming. Huge amount of money which you were supposed to repay. This was it just during your marriage? What was the date of the loan? Let's see. When was the loan taken? Because the complainant has said that some loan was taken and you were supposed to repay the money also, but you had disappeared. And here it is said that the money, maybe you're the family.
My lord, we are not appearing on behalf of David. We are appearing
Page
on
number
behalf
23, that regarding loan. Page number 23.
Page?
Number 23, regarding loan.
So we'll have to see. Anyway, so your submission is what? That you don't know anything about the loan taken by your son, is it? The wife of your first wife of your son. This was on 27th. When was the loan taken?
13 February 2024. The loan date.
2024. That was after you had left. After the son had already left.
Yeah, only they were staying together only 1 week. Then he left.
Then he left.
Yeah.
And then who took the loan? You took the loan?
Yeah, we took the loan. Ask his advice.
And then where's the money? The loan money was given to?
The loan money is with us.
With you?
Yes,
then?
my lord.
How can you blame the mother?
Because we have a bare minimum income, financial resource. That if he is not advised us, we shall not take any loan. We dare not to take a loan. That will be an extra financial burden.
You are the wife, isn't it?
Yes, my lord.
You are the wife, and you had taken loan. For what purpose did you take the loan?
Because of that, I am still living with my parents. After leaving my husband.
How is the husband involved in the loan that you take after he's left?
As he advised only, because due to certain official documents requirement, and it will take some time for taking me to the Israel. During the meantime, my family are having only bare minimum to have a income for supporting our family. And
but you use the loan money for yourself, isn't it?
yes, my lord.
Then
otherwise, if he is not advise us, we shall not take it.
But,
yeah, because we are not.
But if you give some money to him, then you can implead the mother.
Yes,
but you use the loan money, then you have to pay. Anyone can advise you.
Yes,
because
that's true.
Advice, you cannot go and blame
That's
someone.
true.
Then
that's true. Because of that,
anyways,
my lord,
I think I've heard both of you.
let the case be sent back to the trial court. Then with the evidence,
Okay. Anyway,
let us decide from the evidence only.
I'll pass the order accordingly.
Yes, my lord.
Okay, I've heard both of you. Let me consider, because I'm still not very sure of the facts, but now the facts are getting a bit clear.
Yes, my lord.
Isn't it? So you're saying that when the petitioner was heard, her statement was not recorded. If her statement was not recorded, there's no use of calling for the
Because of
TCR
she sought
also,
her
because
erratic.
everything is here. That means everything is available here. There's nothing to be looked into. I was thinking maybe something is still there in the TCR, but it appears that if a statement was not recorded, as stated by both of you, there's no use in calling for the TCR, isn't it? Order sheets are here. Heard, Miss?
Valal Schweizeli.
Valal Schweizeli, Learned Counsel for the petitioner. Also heard Mr. P.J. Lalnantwanga, Learned Counsel for the respondent. Having heard the submissions made, order will be passed. Yes, leave it like that. I'll pass the order within this week. By tomorrow or the after. It will be out. Yes.
Item 16.
May I please your lordship, my lord? This appeal RFA number 37 come up for the first time, my lord.
Oh, motion.
Yes, my lord.
Page. Notice not issued. Okay, we'll issue notice and appeal against her. What is wrong with the judgment?
The suit was dismissed on two grounds. One, limitation, and secondly, on res sub judice.
So,
In my lord, in my case, there was earlier probate case, and that probate case was passed ex parte. And earlier we had filed approach this on the book by filing one RFA, and the probate case was remanded back to the trial court for the novo trial. And after I contested in the probate case, my lord, I filed another civil suit challenging the authority of the testator who made the will. And when both suits are pending before different court, my lord, in the probate case, the London trial court had held that the civil suit should be heard first, and the probate case was kept in abeyance.
okay, so that's why the limitation had set in, is it?
The probate case was kept in abeyance, my lord, and thereafter the civil suit was taken up. But while the probate case was kept in abeyance, the civil suit, the trial court had held that it was res sub judice because of the probate case,
Okay,
while the probate case was already kept in abeyance.
okay. So, where's the order keeping the probate case in abeyance? It was passed by which court? The same civil court or some other court? The same trial court?
Different court, my lord. Page number 115 of my memo of appeal. 115.
Then maybe, anyways, we'll have a look at it. Page 115.
Yes, my lord. The relevant portion is in page number 121. 120, para 25 onwards. 120, para 25 onwards. May I read?
Yes.
However, it is worth mentioning that the later suit filed in the other court in respect of civil suit number 21 of 2024 shall determine the real owner of the LSC, which is the subject matter to be reprobated in the said will, allegedly made by such and such, that the mutation of the said LSC is now in question and is not yet decided whether the mutation has been done following due process of law. That by proceeding in the instant probate case can cause injustice to either of the parties when the outcome of the civil suit can change the entire course of nature of the instant case. That, subject to the outcome of the civil suit, the validity of the purported will left behind by such and such will come into picture as to whether the applicant has the authority to bequeath the said property by way of will. That the outcome shall affirm whether the will has met the legal requirements to be probated as per law. For the above mentioned facts and circumstances, this court deems it fit that the case be kept in abeyance until disposal of the civil suit for the best interest of justice.
So, till the disposal of the civil suit, then where's the order of the impugned order? in
The impugned
civil
order, my
suit?
lord. This abeyance order was passed on 18/9/2024, and the impugned order in the civil suit came on 27/5/2025,
Page?
which I enclosed just annexed to the index, my lord, in my memo of appeal.
Oh.
The relevant portion is in para 13, 14. para 13. The present suit, civil suit, have been filed on 27/2/24 for a degree declaring that the mutation of LIC number from the name of such and such as null and void, and also to declare that the plaintiff is the legal heiress of the deceased in respect of the suit property. As per the Limitation Act, and so the period to obtain declaration is 3 years when the right to sue first accrues. As Srimati Ilsa has already passed away on 2013, and as the present suit have been filed on 2024, after 10 years, this court is of the considered opinion that the suit is barred by the law of limitation. Further, Chapter 8 of the Mizoram Inheritance Act 2014 stated that in the absence of will, the following provisions shall apply.
Okay. So para 15. So you're saying the delay is because of the previous.
We were not aware of these
okay.
circumstances.
Yes, will you show notice?
Yes, my lord.
Not Mr. Victor L. Rabde, learned counsel for the appellant, who has filed the instant appeal. Under section 17, within brackets 2, within brackets small b of the Mizoram Civil Courts Act, 2005, read with Order 41, Rule 1, and Section 151 of the Code of Civil Procedure, 1908, against the judgment and order dated 27/05/2025, passed by the learned civil judge, within bracket, senior division, close bracket, -1, Roman 1, Aizawl district in civil suit number 21/2024. The learned counsel submits that the learned trial court had erred in dismissing the civil suit on the grounds that the suit was barred by limitation and that it was res sub judice, by submitting that there was an order passed in probate case number 2 of 2019, dated 18/09/2024, wherein the civil judge, within brackets, senior division, close bracket, -6, Roman 6, okay, Aizawl district, had held that the case be kept in abeyance till the disposal of the civil suit number 21 of 2024, and therefore the principle of res sub judice cannot apply in the instant case, as noted by the learned civil judge, within brackets, senior division, -1, -1, okay.
And the explanation made in the plaint for the reasons of delay was not considered.
The learned counsel also submitted that the reasons for the delay in filing the civil suit number 21/2024 was also not rightly considered by the learned trial court. Full stop. The appeal is admitted. Issue summons to the respondents. Yes, state is the party?
Yes, my lord. 2 to 3, 2 to 3,
One
2,
is
3, and 4. State.
Learned government advocate accepts notice on behalf of the state respondents number 2 to
2, 3, and 4.
2 to 4. 2-4. Okay. No need to issue formal notice to the state respondents. Notice be issued to the private respondent number 1 through registered post with AD.
My Lord, we are on the same building. If I may be allowed to serve through the stay.
Do it through this verse,
ma'am.
through AD within 3 working days, returnable by 2 weeks.
Yes, my Lord.
2 weeks. List after 2 weeks. Yes.
I have IA, my Lord. If considering the facts and circumstances, my Lord, if the proceeding of the probate case is stayed.
Heard Mr. in the IA. We heard Mr. Victor Elrate, learned counsel for the applicant, who has filed the instant application under Order 41, Rule 5 and Section 151 of the Code of Civil Procedure for stay of the operation of the impugned judgment and order dated 27/05/2025, passed by the civil judge within brackets Senior Division -1, ISOL in civil suit number 21/2024, and to also stay the proceedings of the probate case. But the proceedings of the probate case is already stayed because
No, my Lord.
it says it will await the outcome of the civil suit, isn't it?
My Lord, now the civil suit has been dismissed and the probate case came revived.
This we'll have to see because has notice been issued? Have you been called concerning the probate case? At this stage, the probate case will have to be seen because the last order.
There was an order.
But there's an appeal.
There was an order
pending.
regularizing the probate case now, after disposal of the dismissal of the civil
Have
suit.
you enclosed that order? You see, because the last date till the disposal of the civil suit, but now there's an appeal pending here. So you have to, because this is a completely different case.
That is correct, madam.
Passing an order for that to be stayed at this stage, I think it's a little bit dicey. So we will, if we stay the proceedings or the this thing of the civil suit, automatically you can approach the probate course.
I understand.
Probate case, okay? And also to stay the proceedings of the probate case number 2/2019 pending before the learned civil judge within brackets Senior Division close bracket -6, ISOL. Full stop. Issue notice to the respondents. Ms. Vani Isiami accepts notice on behalf of the state respondents number 2 to 4. Full stop. Notice be issued to respondent number 1 through so and so registered post with AD. Okay, just after 2 weeks. Full stop. Meanwhile, since it is seen that the RFA number 37 of 2025 has been admitted, this court find it appropriate to stay the proceedings of the to stay the operation, okay, instead of proceed, to stay the operation of the impugned judgment and order dated 27/05/2025, passed by the civil judge against Senior Division -1 in civil suit number 21/2024 till the next date of listing. List after 2 weeks.
Orders, item 17.
May I please, Your Lordship?
Yes.
Your Lordship, first of all, I forward my sincere apology because in my last day, I have requested the court to accommodate it Monday so that I can appear there physically. But Your Lordship, I had to return back yesterday due to the adverse condition of the weather. The flight got cancelled. So I apology from my side. Your Lordship, may I proceed with the case?
Yes. Notice complete?
Your Lordship, bail
We are ready?
application under section 483,
Yes.
reduced section 37 of NDPS Act is filed under section 21C of NDPS in connection with session registration case number 278 of 2023. Your Lordship, we have filed a bail application for the accused Abdul Kalam Laskar, who was arrested on 11 June 2023, and since then he has been languishing in judicial custody. It's been almost 2 years, 2 months, 3 months, 2 years, 3 months and 5 days as on today. And Your Lordship, the charge sheet of the instant case was submitted 2 years back, that is on 22nd of July 2023, immediately within the 40 days of being after the arrest of all the accused. Your Lordship, in the charge sheet we have seen there were 14 prosecution witnesses, out of which till date only 9 prosecution witnesses have been examined
14
to the
out
best of our
9.
knowledge.
So how many remaining? 3.
Your Lordship,
14,
out of 14,
13,
5 are still remaining, Your Lordship.
5 witnesses.
And yes, Your Lordship, and there is no chance that the trial will be completed in near future. Your Lordship, Your Lordship, may I refer to the arrest memo? It's Annexure 2 on page 19, Your Lordship. May I read, Your Lordship?
Yes.
SI so-and-so of Excise and Narcotics Department hereby seize the under-mentioned contraventions and vehicle on 11 June 2023 at 12:05 a.m. from the special chamber of a seized vehicle at Zembark East, Khanan Thar petrol pump in presence of the below noted reliable independent witnesses. I also arrest the joint possessor mentioned below on the same date, time and place. Accused number 1, Ms. Muhammad Nazimul Hussain Barbuya, and accused number 2, Abdul Kalam Laskar, that is us. Your Lordship, this is the seizure and the arrest memo, where the reason of arrest is written that from my vehicle some contraventions were seized, but the ground of arrest are not mentioned. Your Lordship may see, this is the only document which we have got where we were asked to sign. Your Lordship, in the notice 47 and 48 of BNSS correspond to notice 50 and 50A of CRPC were not served, which is a mandate mentioned under Article 22, Clause 1 of the Indian Constitution, which clearly writes
you have any authorities to rely on?
Yes,
Are you
Your
having
Lordship.
any authorities, 1 or 2 judgments to rely on?
Your Lordship, may I refer to the judgment of Vihan Kumar, Vihan Kumar
Citation?
versus the State of Haryana, 2025 INC 162. Your Lordship, the conclusion part, para number 21.
2025, the citation 2025?
2025 INSC 162.
162.
Yes, Your Lordship.
INSC. Then in SCC, do you have? What is the name of the case?
Vihan Kumar versus State of Haryana and others.
Okay.
Your
Yes,
Lordship,
Vidhan
we have
Kumar, Yes.
Your Lordship, we have already provided a copy in the hand of local council as well as to the Coastmaster.
Okay. Copy already given?
Yes, but
Yes, sir.
I could not find, only 3 of them I could find on this side.
Okay. Give another copy. You have it with you? He's here. Give. Yes. Para?
Para number 21, Your Lordship.
21,
conclusion part.
same. Yes, mandatory provision, etc. I think if you just mention the para, it will be enough. Okay, para
Obliged, Your
21,
Lordship, obliged.
read this short part.
Your Lordship, I'll just read the conclusion part, that the requirement of informing a person arrested of the ground of arrest is mandatory requirement of Article 22, Clause 1. The information of the ground of arrest must be provided to the arrested person in such a manner
yes,
that sufficient knowledge
yes.
of the basic fact constituting the ground is imparted and communicated to the arrested person effectively in language which he understands. The mode and method of communication must be such that the object of the Constitution safeguard is achieved.
Yes. So you're saying the section's not mentioned?
No, Your Lordship. No, Your Lordship.
relevant
It is not mentioned.
provisions of law has not been mentioned. Yes.
Yes, Your
Okay,
Lordship.
fine. Next, also same principle, the other one?
Yes, Your Lordship.
2024
And
8
based on-
SCC?
Yes, Your Lordship. And may I refer to one more point, Your Lordship? The co-accused who was arrested with me, whose name is there in the same arrest and seizure, that is accused number 1, Nazimul Hussain Borguia. He is also granted bail only because of this particular ground by the Honorable Guwahati High Court Aizal Bench by order dated 14/06/2025.
Yes.
Your Lordship,
yes,
I have also submitted that
it's here.
judgment.
Okay.
Yeah.
This is
Your
dated
Lordship-
14/07/2025, is it?
Yes, Your Lordship. Yes, Your Lordship.
On the
Your
same
Lordship-
ground?
Yes, Your Lordship. On the same ground. May I refer to the
Co-accused
point
was the
of-
driver or the handyman? You are the driver or the handyman here?
Your Lordship, I am the handyman here.
Handyman.
And
The driver
yes,
has been released.
already
Okay.
released, Your Lordship.
Yes.
So,
Okay,
do I
that's
have to refer to the point that I was granted bail on this particular ground, Your Lordship, from that order of the Honorable Court?
Yes, please read that particular para.
Okay, Your Lordship, Your Lordship, para number 14.
1-4. Okay.
Yes, Your Lordship. May I, Your Lordship?
Yes.
In the present case, it is clearly discernible from the material placed before the court that the accused or petitioner was not informed of the ground of arrest. No document whatsoever are available on the record to indicate that the ground of arrest are contemplated under Section 21, under Article 22, Clause 1 of the Constitution of India had been informed to the accused or petitioner. Moreover, the case record does not indicate any contemporaneous record indicating the ground of arrest was told or informed to the accused or petitioner at the time of arrest. Hence, I have no hesitation in holding that the arrest of the accused or petitioner is totally illegal and invalid on the account of failure to inform the ground of arrest to the accused or petitioner as mandated by Article 22, Clause 1 of the Constitution of India.
Okay. Same ground, same facts of the case.
Yes, Your Lordship.
The driver
And same
has
seizure.
been granted bail, and it is seen from the arrest memo that the section of law
Yes,
has
Your
not
Lordship.
been mentioned. Yes, anyway, we'll hear the additional PP. Let's hear her. I think I've made your submissions, that is, it's clear enough.
Yes, Your Lordship. Yes, Your Lordship.
Yes, Your Lordship. What I would like to mention regarding the violation of Article 22(1) of the Constitution of India. Your Lordship, and the appellant had relied on Vihan Kumar cases. And Your Lordship, what I would like to mention is that if we looked into that Vihan Kumar case, the Supreme Court has held that where there is a clear violation is established. So if it is established clearly, then the arrest stands vitiated. And however, Your Lordship, in the instant case, as we can see in the seizure and arrest memo, as well as the report of seizure and arrest, here we can see that the appellant had put his signature, and knowing that his grounds of arrest was for the illegal seize of the contraband articles. And in page number 2, it can be seen that intimation of arrest is informed to each of the family of the arrested person. This is for your kind favor. So intimation is also
Given.
given to the family. So, Your Lordship, the ratio of Vihan Kumar cannot apply in the present case because there is a compliance of Article 22(1) of the Constitution.
The sections have not been mentioned, section of law.
Yes, Your Lordship, the section is not mentioned, but still, the reason why they were arrested is duly compliance, was duly communicated to the accused, and they know it very well that on what grounds they have been arrested. And regarding to the present appellant, he is the one who has taken out the seized article from the special concealment place. He is the one who took out the seized article and he handed over to the seizing officer. So the involvement of the appellant is very clear, and it is proved that he is having conscious possession regarding the seized contraband. And regarding the parity, Your Lordship, parity is not an absolute right and cannot be applied mechanically without considering the appellant's role in the case.
Okay, you're reading from?
I have citation.
Citation, give me the citation.
Yes. I have two citations.
Hmm.
2025 SCC Online SC 1100. Para number 20.
Yes.
Here it is stated that, if I may read out, Your Lordship, the High Court therefore failed to consider these above grounds and has mechanically passed the order and allowed the appeal. The order of grant of bail to accused on parity is error apparent on the face of the report. The High Court failed to consider that the accused are the main accused in the matter and cannot be enlarged on bail because of the other co-accused person have been granted bail. So, Your Lordship, it is very clear that on the grounds of parity,
One is the driver, he's a driver, while the other co-accused was the handyman. And it was the driver who took out the contraband
the handyman is the
substances
one.
from
The handyman is the
okay.
one who took out the contraband, who is the present appellant in the present case. And Your Lordship, another.
But what about the observation of the coordinate bench of the court saying that grounds of arrest was not given to the. Now, there's no appeal against this point, grounds of arrest.
Yes, Your Lordship, regarding to the grounds of arrest, Your Lordship, in my humble opinion, the seizing officer had duly compliance with the Article 22(1), stating that he is arrested
But
because
the
of the
same
seizure
memo of arrest was given to both the accused persons.
Yes, they were given.
And the coordinate bench of this court holds that ground of arrest has not been complied with based on the same, this thing. See, because if this court, I'll have a look, if this court
May I
were
please,
to
Your
differ,
Lordship?
Yes.
Your Lordship, to the point where where my learned senior is saying that the seizing officer has informed me. So, Your Lordship, in the Honorable Apex Court clearly distinguished the reason of arrest and ground of arrest are two different things. Your Lordship, for that, I would like to refer to the judgment of the Honorable Apex Court, that is Praveen Purkasthia versus State of NCT Delhi 2024.
Have you finished?
8 SSA
Ms. Vani
2054.
Siami, have you finished your submissions?
Not yet, Your Lordship.
Let her finish her submissions and you can.
Apology, Your Lordship.
And Your Lordship, what I would
Yes,
like to
yes.
mention is that Article 22(1) is a safeguard, provides for safeguard, and not a ticket to automatic release. So without having established the violation of Article 22(1), the ratio of Vihan Kumar cannot assist the appellant. And in the whole case, looking at the evidence of the prosecution witness, there is not even one question raised about this violation. No question were asked to the seizing officer regarding this violation. So it was not established. The appellant failed to establish the violation. And Your Lordship, what I would like to mention again is that in this present case, the appellant took out the seized contraband from the place of concealment and handed over to the seizing officer. So this seizure squarely falls within Section 22(7) of the Indian Evidence Act, Your Lordship, because this is in this section that is the exemption of Section 25 of Indian Evidence Act, and the seizure made under falls under Section 27 Evidence Act 2000, Section 27.
Indian Evidence Act, what is the corresponding? We don't have the Indian Evidence Act anymore. Then what's the corresponding this thing in the BNS?
BNS.
Actually, we should be using the BNS, but since you're not, find out what is the corresponding section, isn't it?
Yes, Your Lordship.
27. We should not come back to this after later, but since you're not prepared, we'll look at 27.
What I'm thinking is that since this whole present case is dealing with the previous law, that's why I'm not
before the
ready with the new act.
2027. Okay. Yes. 27. Huh. Oh, so this was, when was it seized? On the seized articles? Case was, initiated before the amendments, is it?
Yes, Your Lordship, before the amendment.
Yes, so 27, what does it say?
When any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved.
Section 27?
Yes, Your Lordship.
Concerning, how much, just read section 27 of the Indian Evidence Act.
How much of information received from accused may be proved?
Yes. Provided?
Provided that when any facts is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the facts thereby discovered, may be proved.
So you're saying the information received from the accused, who's a driver, is that he had removed the seized articles.
The handyman is the one who took out.
But the instant case is a driver?
No, Your Lordship, the appellant is the handyman.
Appellant is the driver or the handyman?
Your Lordship, he is the handyman.
He's the handyman. Okay, so the handyman had taken out. Okay, fine. Okay.
So, Your Lordship, what I would like to mention is also that the present appellant is not from Mizoram.
Applicant.
Applicant.
Actually, it's not a petitioner.
Applicant is
I made that to use the wrong term.
He is not a native of Mizoram. So if he is released on bail at this stage, there is a high risk of absconding. And with that one, I will conclude my
remaining
submission.
5 distinct prosecution witnesses. Who are the 5 remaining prosecution witnesses? Why haven't the trial been completed after 2 years?
The evidence, all the evidence were not annexed by the applicant in their application, Your Lordship. So,
but do you know who are the remaining 5 prosecution
I cannot say at
witnesses
this
yet
time
to be
who are they.
examined?
I cannot.
You see, you can
say
look.
that who are examined.
Simply
already.
keeping it pending, you have to know what is the importance of the remaining 5 witnesses. The seizing officer has been examined.
Examined.
FSL examined. Some of them have been dropped also, it appears. Yes, who are the remaining 5 prosecution witnesses yet to be examined? Do you have any idea? The petitioner, applicant?
No, Your Lordship.
Okay, fine. Yes, so.
Your Lordship,
completed
I have to.
in rebuttal,
may I?
what do you have to say?
Your Lordship, as the Honorable Ma'am has said, that I was informed that these things were recovered. But the Honorable Apex Court in the judgment, Praveen Purkastia versus State and City of Delhi, 2024, 8 SSC 254. A copy is already submitted, Your Lordship. Para number 48, I would like to refer to the para number 48, where the distinction...
Yes, reason between reasons and grounds. Okay,
yes,
that
are clearly
distinction,
explained, Your Lordship. It is clearly explained. And one more thing I would like to refer is that, Your Lordship, based on parity ground, from the Honorable Court of Your Lordship, from your court, co-accused Kutbul Alam Laskar already got the bail on order dated 29 of July 2025, who was, as per the statement of the seizing officer, is the mastermind of the entire thing and possessor of the actual drug. He also got the bail, Your Lordship. May I refer to the order, Your Lordship, of the Honorable Court?
Bail application 25 of 2025, yes.
No, Your Lordship, bail
Which
application
one?
25 was of the driver, Your Lordship. And based on the order of the driver on the parity ground, another co-accused is also granted bail
How
by
many
the Honorable
accused are
Court.
there? 3 accused persons, is it?
No, Your Lordship, 4 accused persons were there,
Okay.
out of which 2 were already granted bail, Your Lordship. The first
So
one
you're
got
the
bail.
third. What about the fourth
Yes, Your
one?
Lordship.
Fourth one also
And-
must be attempting to be released on bail?
Most probably, Lordship, because they were languishing in judicial custody for more than 2 years. And Your Lordship, in the Honorable Court, Apex Court, in different citations have told that the court can relax the rigors of Section 37 of NDPS Act for bail if the accused has no criminal antecedent and has spent a considerable time in custody, for which I would like to refer the judgment of Supreme Court of India, Mahendra Appellant versus the State of Rajasthan.
Citation, have you given me the hard copy or no?
Yes,
You
Your
have
Lordship,
given?
I have already submitted the hard copy.
Okay, which one? Please repeat the citation or the name.
Mahendra versus State of Rajasthan, 2025
Okay,
Supreme
yes.
Court online. In the very first page itself, Your Lordship, it has been written, the court can relax the rigors of Section 37 of NDPS Act for bail if the accused has no criminal antecedent and has spent considerable time in the custody. Your Lordship, the accused is already behind the bar since a long time, Your Lordship. It's more than 2 years, 2 years, 3 months and 5 days. And Your Lordship, he also has the right, the fundamental right of Article 21. He has also the right to fight for himself for a free and fair trial. If he remains behind the bar, he will not get that opportunity.
Okay, fine. I got your point, huh? Yes, that's
Obliged,
it.
Your Lordship.
Anything else?
Your Lordship, on the last, I would just like to refer the last bail order, which was given by your Lordship yourself. That was on dated 29/07.
You have given me a copy?
Lordship, perhaps I have not provided the hard copy. It was from the Honorable Court of yours.
Even then, we'll have to dig out
I
how
will
many
leave it
bail
from my side, Your
applications have
Lordship.
been disposed of. How can I know? Yes.
Sorry, Your Lordship.
Give me a copy
Next
anyways. Dated
29/07, 2025, Your Lordship.
in bail application number?
Bail application number also 29/2025, Your Lordship.
Okay, give me a copy later. Okay.
Obliged, Your
yes.
Lordship. Obliged, Your Lordship.
What happened then?
I will refer to the relevant part, para number 9. The court has noted that only 4 prosecution witnesses out of 14 witnesses have been examined till date. Thus, the court is of the view that the issue whether or not there is sufficient evidence against the accused to convict him under Section 21C NDPS Act can be decided by the learned trial court after the conclusion of prosecution evidence.
But one thing I've noticed, wait, huh?
Yes, Your Lordship.
Okay, but the bench is not sitting. Otherwise, one court which passes a bail from the same FIR, it should have been placed before the same judge. So when it was placed before one of the judges in bail application 25 of 2025, it should have been placed before the same judge. But anyways, since
Yes,
it's
Your
not
Lordship.
sitting, anyways, yes, go ahead.
Para number 11, Your Lordship. This court has, however, taken the note of the fact that the co-accused in the case, Mr. Nazimul Hussain Borbuya, who is the driver of the vehicle, where the seized article was seized in presence, was granted bail by coordinate bench of this court on 14/07/2025 in bail application number 25 of 2025. Thus, applying the principle of equity and fairness, this court is also constrained to grant the bail to the accused with a bail bond of rupees 1 lakh with one surety of the same bond amount, who shall be to the satisfaction of the learned trial court.
Yes, okay. Is that it? Yes, heard. Miss, your good name?
Lubna Chaudhary, Your Lordship.
Lubna
Chaudhary.
Lubna Chaudhary, learned counsel for the petitioner. Also heard Miss Mani Isyami, learned additional PP for the state respondents. Yes, reserved for order. Matter is reserved for order. I'll pass the order accordingly.
Highly obliged, Your Lordship.
Yes, now it's lunch break. What do we have? Hearing or what?
Well, look, regarding limitation.
Limitation.
Condonation of delay application, my lord, is to be
Okay, so
heard.
the matter is ready for hearing, is it?
Ready for hearing, madam.
Then after lunch at
My
2
lord.
o'clock. we can
My lord.
continue.
Your Lordship, if this matter may be listed tomorrow, since I have to appear on VC, bail hearing
Okay,
matters
so
at 2
she's
o'clock.
the opposite party.
Yes, my lord.
Okay, this is item number 18.
18.
On the submissions made by the learned counsels, list tomorrow's date.
Obliged.
What about 19? Anyone present waiting? 19?
18, my lord.
18 is there. Oh, wait, a lot of cases are still there, so we'll continue at 2 o'clock. Yes.
Item number 19.
Yes, may it please your lordship. My lord, this IA pertains to an application for continuation of delay of 136 days. And there are, a notice has already been served through Talabana. However, ID card has not been
So we
returned
have to
till
wait
date.
for return of
and
ID card.
Your Honesty, there is some urgency in this case. If I may be allowed to serve notice through dusty mode.
Okay. Heard Miss
Ishla Rausani.
Ichla Rosani, Learned Counsel for the applicant.
Yes.
Who submits that since ID card upon respondents number, all the respondents are what? Respondents
Only
number?
the private respondent. One-
Since ID card upon the private respondents number
1 to 11.
1 to 11.
11. My lord, if I make a prayer
returned
in that
till
regard.
date, Rama, she prayed that she may be allowed to serve notice upon the private respondents through dusty mode by expressing that there is urgency in the matter. In view of the above submission, the learned counsel for the petitioner is allowed to serve notice upon the private respondents through dusty mode, and affidavit to that effect is to be filed accordingly. List after, how long will you take?
2 weeks.
2 weeks. So, the presence of Ms. Lalnampu, learned government advocate for the state respondent number
11 and 12, Your Lordship.
11 and 12 is noted. Yes.
And my lord, in that regard, in the trial court, a power of attorney was executed by this petitioner, the respondent herein, to in favor of Zion Ramgaya, who is the son of the respondent number 9. So if I may, if a notice may be given,
whatever, what notice to whom?
to this Zion Ramgaya,
Zion,
since he is the power of attorney holder. He is the son of respondent number 9, if it is possible, and if your lordship.
You through dusty mode, you do it. The private respondents number 1 to
1 to 11.
11.
Yes.
Through whichever mode you want, that you can do in the dusty mode, whoever
Yes.
receives it.
Yes, your lordship.
Yes.
And
Item 20.
yes, item 20, same prayer, my lord. In this regard, there is only two private respondents.
Okay, private respondents number 1 and 2.
1 and 2.
1 and 2. Yes, same order.
Item 21.
Same
And in
order?
this,
No.
same prayer, my lord. And in this case, there are 3 private respondents.
Okay. Private respondents 1, 2, 3. What
Item
about
22.
22?
Same prayer, my lord.
How
Private
many?
respondents 1 to 5.
1 to 5. Yes. Then, all connected. What is the matter
Yes.
about? Huh?
The matter is regarding land acquisition, my lord.
Okay.
Yes.
So 23 will be private respondents number
1 to 42. Same
1
prayer.
to 42. Then government advocate will be 43. Is it? 43 and 44. Government advocate respondent. Okay. So in the others, next 2 numbers. Yes, 24. It's different. Okay.
Item 24.
Yes.
May it please your lordship. Lordship, I have filed this IEA numbered 165/2025 for the reason, your lordship, what has happened. Your lordship, we had preferred in first appeal before this honorable court. Our probate application which has been filed for the district court was dismissed, and thereafter we preferred an appeal. And in the meantime, the appeal was admitted by your lordship, and the opposite party thereafter entered their appearance and they filed their power also. But what has happened during this period, the respondent number 3 has withdrawn an amount of 10 lakh rupees from the bank by depositing a succession certificate.
So, but you have not challenged the succession certificate, have you?
No, Your Lordship, what is the issue in here is that the account of the deceased, from which it has been withdrawn, it is specifically mentioned in the will, dated 1st of June, and the will is under challenge. So
Will is under challenge, but succession certificate was also issued.
no, after, because what has happened, this whole incident has happened during the pendency of the appeal, after the appeal has been admitted, and the respondent is well aware of that the appeal has been admitted. I can show from the facts, if Your Lordship will give me just time, I will take Your Lordship through it. If Your Lordship may turn to page number 4 of my IA. So what has happened, I will see. On 30th of May, the appeal was admitted by this Honorable Court. Then on 24th of June, the respondents came and filed their power. So the concerned advocate.
So when was the succession certificate issued?
27th of May, after they have entered their appearance in the High Court. 24th of June, so May.
Then you'll have to also pay for the stay of the succession. So have you mentioned that?
Your Lordship, stay of the successor,
I have
now
not
what has
only
happened
obtained the succession
regarding
certificate,
one bank account.
tried to withdraw, but they did not withdraw.
No, he has taken the money, he has withdrawn it.
Oh. Because the succession certificate
So
was
what he tried
issued,
to do,
isn't
actually
it?
there are two accounts of the deceased. One is a current account, he has obtained succession certificate, that is at page number
'Who are the parties here? Children of
like I am
the
the
deceased?
what is the children, I am the second wife, alleged.
Okay, he has
So
a second
yes,
wife.
and the first wife's two sons.
So he was married with the second wife for how many years?
Almost like more than 20 years. 20, even in his pension book, my name is written. He was with me in the hospital. These are like matters of facts, but
You
still,
see, these people are well-known people, and after their death, I don't know why. Anyways, have you made any attempt to come to some settlement? What are the properties left behind by him? Whether, see, if he's been married for more than 20 years,
page number 15.
the children through the first marriage and the second wife, they've all been living together for.
No, the first wife, actually, if the records what he suggests is that the first wife had no relation since almost like 20-25 years with the
But the
deceased.
children are there.
Even with the children, he has no relation. And in the will, if I may read the will, which is at page number 15.
Do you think you could come to some settlement? Because you are basically fighting over the properties
Yes,
left behind by the deceased.
Yes, Your
Okay.
Lordship.
There's no denying that his children are, that the sons are also his children. Whether they live together, it's a different matter. And with the second wife, how many children did he have?
One daughter.
One daughter, isn't it?
Yes. But Your Lordship, before it,
The IA they will consider, that IA will consider, but isn't there a possibility of them coming to some settlement by coming to, if you come to an amicable settlement, you can look at the list of properties left behind by him, and it can be also distributed to the satisfaction of both the parties. Isn't it?
Your Lordship, what has happened is that if you see their conduct, like no, I don't want to personally.
All that will happen because you are this thing.
And when there is a will, there is a bona fide will. Because of some unfortunate events, I will take Your Lordship when the time comes. I will into the merits of the case, and we have filed a petition for adjudication.
So the respondents are saying this is not his will.
The will, yes,
Yes,
saying-
my lord. The will cannot be probated. That is our stand.
Oh.
And Your Lordship, at the same time, I would like to. I would like to
Yes.
file the written objection in this IA because
yes, you'll
there
fi-
is a
you'll
separate
file.
this now they are asking for stay or passing for injunction order in respect of the succession certificate case, which is a different case, my lord. After dismissal, no, my lord. After sorry,
No, you'll file a written objection.
Yes.
It's okay. But I'm just looking at page 14.
14.
Okay. Long list of properties.
yes,
Okay. long list of properties left behind by the deceased. So I think there will be enough for everyone if you agree to come to some settlement.
I can instruct the client, my lord.
So you get instructions.
Yes.
In the meantime, we'll issue notice and also status quo be maintained for the time being. Isn't it?
And your lordship, my humble prayer, your lordship will look into it, because what has happened, even if we want to settle for talks, like, sit down and have some discussion, there should be a cordial environment. Suppose
Obviously, there will be.
but in
There
this
will
kind
be.
of
There
act
will
is
be.
actually
Mediation takes care of all that. Don't have to worry.
No,
Even
your
the
lordship,
room
what is-
itself, it's made sure that it's.
No, what has happened if you see the conduct? I am like, no, now the single wife, my daughter is staying abroad. So now there is some.
No, you can
acrimonious-
trust. See, I think mediation will be better because 40 hours training has been undergone by the mediators. So I think. What do you feel? You want to go to Lokada? You can this thing.
We'll speak to the clients
get
first.
instructions from your
Yes,
clients.
I will.
And my lord,
Advise them that it is for their interest if they come to some settlement.
I will
Okay.
definitely convey.
Fighting over property, long list, there's enough for everyone.
and my lord,
As I said, just don't be greedy.
yes. My lord, one small submission, your lordship. Regarding the present application, after probate application was dismissed, and although the appeal was admitted, no stay was granted against the impugned judgment and order. Plus, thereafter, after dismissal of the probate application, we applied for succession certificate in respect of the bank account, this particular bank account. That is
because
the
of
separate
this-
proceeding, and it was granted on 3rd of July, and accordingly, in pursuance thereof, I had applied for withdrawal of the money. So, if they are
You issue, they say,
yes, if
we
they are
issue
trying
notice, you file a written objection.
yes, no,
concerning
status
this.
quo may not be maintained also, my lord, because in order to get the injunction order, whether it's interim or otherwise, then they have to first challenge the succession certificate.
what I'm
Otherwise, it won't be
asking. Is
possible.
there a
No,
cer-
No, they
Lordship,
cannot
I will
directly
clearly-
do
I will
that.
just point out the fact, the succession certificate we did not challenge, because succession certificate is a different proceeding and not challenging it also. What is our prayer before this honorable court is that during
Because
the
in
pendency,
the
when
will,
the appeal
in
was
the will,
admitted,
it's been mentioned.
in the will it is mentioned, it is part of the estate of the deceased, and when the succession
Okay, so we
certificate
it was
simply
dismissed.
pass an order that
And the will- and the appeal has been admitted.
none of the properties within the will,
mentioned, this
which
is the, yes.
in the RFA,
May not be
okay, is
disposed
to
of.
be this thing
Yes.
disturbed. Okay, so
Because
status
other-
quo-
tomorrow even if I win,
status
nothing
quo
remains.
regarding the
Estate of the
properties
deceased.
mentioned in the
Will.
will.
Maybe.
Okay, till this. Then in the
That's
meantime,
fine.
you get instructions.
Yes.
I will
from
seek
your
instruction,
clients.
but I believe one major point will be to deposit the 10 lakh in the court.
No,
No,
we
no,
strongly
no,
object.
no,
yes,
no, 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 don't
Then
speak,
we'll see.
don't speak
Yes.
for your clients.
No, no, no,
okay?
I know, because I had to, because your lordship, they're really scared now.
See, no,
Unless
no,
and
no.
until they
Listen,
challenge
listen,
the
crying
succession.
that day.
listen, if you want them to come to a settlement, okay, they have to have their state of mind has also to be prepared by the councils. Okay, don't say this is mine and that is mine. Okay, say how are you going to come to a settlement? Leave that as it is. If you come to a settlement, all that will be settled. Don't demand anything yet.
Your lordship, I'm, so,
No,
I'm not telling, because if you see the plight of the petitioner today, you will also, your lordship will have really appreciated my statement.
You
because
inform the.
I will inform, I will
this thing.
definitely inform.
You inform that come to a settlement, there is no dispute that cannot be settled. Okay, it is only your state of mind and your heart that has to be changed. If you have that attitude of, agitating your rights, then it becomes difficult. What you have to do is try and settle. It's for the benefit of both of you.
Your lordship, I totally respect.
So the list of properties in the mediation, I think they can come, you could come to a settlement, okay, where the properties of the deceased, who was your husband for 20-something years, and the other side, the children of the deceased. Okay, don't fight over property. It's
No,
very-
your lordship, may I just make
Ha,
one
ha,
submission
ha,
if
ha.
it's allowed? Your lordship will kindly take into consideration the fact, I'm not saying
I'm
disputing
not
a
going to be
mediation.
I'm
No.
not going to the mediator, so leave it to the mediator, all those things, okay? Yes. Anyway, heard Mr.
GR Datta.
G.R. Datta, learned counsel for the applicant/appellant. Also heard Mr. B. Lalramenga, learned counsel for the respondents. The before that, before heard Mr. So-and-so, learned counsel for the applicant respond, this thing, the applicant / appellant, okay, full stop. Then, new para, this is an application filed under order 39, rule 1 and 2, read with section 151 of the Code of Civil Procedure, 1908, and section 39 of the Specific Relief Act, 1963, to pass an order of injunction or status quo
And-
regarding the estate of the deceased Sri Robert Shangdola, with regards to the properties mentioned in the will dated 01/06/2020, which was executed by the deceased Robert Shangdola. The learned counsel for the applicant submitted that the amount of rupees 10,32,848 was withdrawn from the account of the deceased Shangdola, account number 20094946660, and the from State Bank of India, and amount of rupees 76,647 and 72 paise from Baroda branch, Aizawl branch, from account number 308001, then 50109, wherein the respondents had withdrawn the said amount by obtaining a succession certificate from the court of, which court?
Civil Judge, Senior Division 3.
Civil Judge, within brackets, Senior Division dash Roman 3. Full stop. The learned counsel submitted that since the said bank accounts were also mentioned in the will of the deceased, which is the subject in dispute in the connected RFA number 19 of 2025, wherein the said RFA has been admitted, the learned counsel prayed that status quo be maintained regarding the said bank accounts of the deceased Shangdola. Okay, first up. Make it always mention Shri. Okay, so just Shri. Issue notice to the respondents, Mr. B. Lalrena, learned counsel, accepts notice on behalf of the respondents. Mr. Requisite copies of the IA to be duly furnished to the learned counsel for the respondents. This court has also heard the submissions made by the learned counsels, wherein the parties in dispute are the children of the deceased Shangdola through the children or the wife?
Including the wife also, my lord.
Okay, the wife, not the children.
Yes, the first wife and
are between the first and second wife of the deceased Shangdola regarding the will.
The children also.
First wife and 2 sons.
Okay. No, between you are the first or the
Yes,
second?
first wife and the sons on
between
one
the
side.
first wife and sons of the deceased Shangdola and the second wife of the deceased Shangdola in respect of the will said to be executed by the deceased Shang Dollar, dated, will is dated
1/6/2020.
1/6/2020.
01/06/2020.
2020.
Full stop. Comma, this court finds that the matter is appropriate to be referred for mediation. Full stop. Accordingly, the learned counsels for the parties are to get necessary instructions from their respective clients. Full stop. List the matter again when?
After 2
Next
weeks,
week?
After 2 weeks, maybe.
After 2 weeks to find out
Oh,
whether you want it
next week, my lord.
in the next week.
Yes.
Okay. Meanwhile, status quo is to be maintained regarding the properties mentioned in the will of the deceased Shang Dollar. Okay. Dated so and so, same date. Yes.
Deeply obliged.
Much obliged. We'll try.